Hi everyone, welcome to this conversation with Professor Kalpana Kannabiran. And today we are going to talk about from text to praxis in terms of legal theory, caste, and feminist thought. I'm going to very quickly introduce our illustrious speaker who doesn't need much of an introduction. Professor Kalpana Kannabiran is a sociologist and legal scholar whose work has focused on the intersections of sociology, law, literature, gender studies, and social movements. Among her books are Tools of Justice, Non-Discrimination, and the Indian Constitution, published in 2012, Law, Justice, and Human Rights in India, Short Reflections, 2021, and Gender Regimes and the Politics of Privacy, 2021, co-authored with Swethaa S. Ballakrishnen. She has edited two volumes of Routledge Readings on Law, 2022, edited and translated The Speaking Constitution, Sisyphean Life in Law by K.G. Kannabiran, 2022, and edited Law, Justice, Society, The Selected Works of Upendra Baxi, Volume 3, Law and Society, 2025. Her latest work is a book titled Caste of Gender, Anti-Socialities, Embodiments, Politics, which will be out in December 2025. So maybe you can check that book out. She is currently Distinguished Professor, Council for Social Development, New Delhi. Professor Kannabiran, welcome to this conversation on doing sociology. We are really glad to have you here.
Thank you, Rituparna, and thank you to Doing Sociology for this invitation and for the interview. It is my privilege to speak to you.
Right. We have had one interview with Professor Srimati Basu on ethnography of courtrooms, and this is, I think, the second one in terms of sociology of law. So we are very excited to have you answer some of our questions, and I hope that young scholars trying to work on the intersections between the social and the legal benefit. Let me begin this conversation by asking you about this idea of constitutional morality, which you have also talked about from a sociological lens. So, how do you conceptualize this relationship between law and lived experience?
Yeah, that's actually a useful point to begin with. Since the term constitutional morality dates to the time of the drafting of the Indian Constitution, I mean, prior to its coming into force. So we're talking about 48, 49. I think it's particularly useful to begin with that concept because that's also the time, as Professor Upendra Baxi constantly reminds us, it's also the time that the UDHR is being framed and is coming in, is preoccupying nations across the world. And for me, I mean, to contextualize constitutional morality in lived experience, I would, rather than speak first about the Constitution, begin with Article 1 of the Universal Declaration on Human Rights, which is all human beings are born free and equal in dignity and rights. And if we remind ourselves that of this, crucial framing of the language of human rights and the language of, for me, also constitutional morality, my immediate concern really is if all human beings are born equal and free, how would we understand constitutional morality in the context of what is happening in Gaza? So my concern is in terms of how we look at, as sociologists, how we look at and comprehend events and experiences and histories, not just our own, but around us as well. And in this context, I think looking at questions of justice, of constitutional morality, and of peace, where constitutional morality for me is intertwined with the UDHR, our question to begin with should be, as Indian sociologists, how would we frame the question of justice and of law as transformative in the context of Gaza and Palestine. How does Gaza today alter our frames of understanding justice? Because we're constantly talking about the local and the regional and the global. And I really want us to resituate the global, because I think that that move from looking at how Gaza shifts our lens to understanding justice will also influence the way in which we approach and understand and renew our commitment to the Indian Constitution in a more transformative way. So having said that, if I, kind of look at the context of India, and so, the point that I also constantly have is why don't Indian sociologists have a platform of Indian sociologists for justice in Gaza and Palestine? I think that is a really important practical and and theoretical engagement that we need to put right at the center of the way in which we imagine the question of justice. And if you look at, if you look at it from there, I think my whole, engagement with constitutional morality begins, in fact, not with the law. It begins with lived experience. It begins with understanding the question of civil liberties in the Indian context. And again, we have a very different turn to civil liberties in this period that Gaza defines, but I won't go into that at length. But my engagement with the question of constitutional morality actually begins with illegal arrests, detentions, encounter killings, unfair trial, execution of political prisoners, and so on, that takes an upward curve during and just before the emergency. Yeah, and even here, I particularly have the experience of AP in mind, of the former state of Andhra Pradesh in mind. And so it is from that experience that we begin to ask, how would we define the right to life, liberty, and freedom under the Constitution in the context of arbitrary state action? And so the law, in fact, comes into focus through the denial of constitutional freedoms to whole classes, particularly of political prisoners. Prior to the emergency, also in the late 1960s, you had the massacre of Dalits in Kirvenmani, which defines our understanding of caste violence and caste discrimination, the linkage between liberty and non-discrimination that I constantly make. So it is from the idea of offering protection, constitutional protection against depredations of the state and dominant actors, that the law spins into focus, as far as I'm concerned. And so the framing of constitutional morality for me, in that sense, is pretty clear. What constitutional morality does is that it opens out the text of the Constitution from an abstraction to something that is rooted in context. Because we can't really understand the Constitution in abstraction as a collection of precepts alone. And so what are the ways in which those precepts are grounded? How are they grounded differently in different situations and in different social locations? How are they grounded differently in different historical moments? Yeah. And what are the denials and what are the erasures that result in our examination of the halting ways in which the Constitution has offered protection to vulnerable communities and people. This vulnerability could be from political belief and freedom of conscience. This vulnerability can be from caste. The vulnerability can be from minority status. It can be from sexual and gender identity. And so the vulnerability is intersectional and can shift from one context to another. And there are very often multiple vulnerabilities. No single person embodies a single vulnerability alone, and they're interlinked, and there's a constant interplay between them. Yeah. So it is in that context that constitutional morality comes into being. The basic question then is, how do you imagine justice for communities either temporarily or persistently on the edge of precarity? And what kinds of precarity? Yeah. So basically, on a broad frame, I think that would be my approach, or that has been my approach.
In your work, you speak of the Indian Constitution as a transformative document, and you're just also mentioning that. So, what does this mean in the Indian context?
Well, if I think the point at which it becomes most visible and voluble, that transformational element becomes most visible and vocal in a sense, is in the context of caste. If you look at Article 15, Article 17, and Article 23, but particularly Article 17, yeah, it is in this in this cluster of articles that you actually find that what is sought to be done through the Constitution is a radical restructuring of Indian society, using Dalit experience and the Dalit experience historically as the point of departure for imagining Indian society in transformative ways. You could then also look at several other ways in which the Indian Constitution, promises transformation. And for me, that is important. What is important is the promise of transformation, which is not to be confused with the delivery of transformation. And I think that we constantly, as scholars who straddle law and sociology, are, we are constantly told that there is a gap in law and its implementation. I don't think it's a gap of law and its implementation. I think it is the ways in which dominant society obstructs the workings of the law and constitution. And the dismantling of that obstruction and the dismantling of that dominant society is part of the project of the Constitution. It's part of its purpose. Yeah. And so it is a continuous road. It is a continuous struggle. The minute we say this is a gap between law and its implementation, it's as if it is a box open and shut. Yeah, and you open the box of implementation and things will be sorted. But implementation is not something out there. Yeah, implementation, the lack of implementation is actually the obstruction of the law by dominant society. You see it in several instances of caste atrocity. You see it in Keralaji, you see it in Melavalavu, you see it in Kirvenmani. You saw several attempts at it in Chundur, but, and I know the kind of Herculean efforts it took to actually fight that obstruction and get convictions in Chundur. But you saw it also in Karam Chedu, and you could go on. You see it in Hathras. So it's not something that stops in 67 or 69, right into the present. You see it, spreading out and spreading thick and strong. So the transformative potential is the ability of social actors who are committed to the Constitution to act insurgently and to dismantle dominant society in the everyday, in different contexts, locally, through everyday actions, as well as come together to oppose and challenge larger actions of the state and larger atrocities. Yeah. So we can't, it's not a question of scale. And I think that we need to occupy every part of the threat that dominant society poses in order for the Constitution to be transformative.
Right. So, one question about feminist legal theory in India, and how do you think it sort of either differs, or do you see parallels with the Euro-American counterparts?
Well, I've actually been a bit bothered about any kind of easy distinctions or dualisms or binaries between India and the rest, or India and the West. Yeah. And I think there are the fact is also that feminist legal theory is contextual. It is specific to context. And we need then to understand how feminist principles and ideologies take birth and are rooted in particular historical and cultural contexts. And then how you can forge a conversation across and between contexts and forge solidarities across and between contexts. Yeah. So it's not so much how it's different, but it's bound to be different because societies and dominant society in Europe, Western Europe, and North America, dominant societies are structured very differently from dominant society in India. Yeah. And but there are ways in which feminists across the board have tried to grapple with and challenge dominant societies. And I think the specific ways in which we do them, or the specific strategies, or the specific programmatic route we take, really depends on our own location and the contexts within which we work. There has of late been large and ongoing debate on intersectionality. Is it good? Is it bad? Is it useful? Is it not? I have actually been at meetings with where feminist friends have said intersectionality is all rubbish. Yeah, I mean, at feminist gatherings where friends have said intersectionality is all rubbish. Now, I, for one, I mean, I know that it has become part of a governmental appropriation, the term itself. It's become extremely opaque, and every governmental body, from local to global, just inserts the word intersectionality and thinks that all diversities and pluralisms and marginalities and vulnerabilities are taken care of. And that is, of course, the danger, because, and that's a danger not just with intersectionality, but with any concept, that you must be mindful of not slipping into using concepts with an opacity. They must, you must open them out for each context quite specifically. Yeah. So if you look, for instance, at the ways in which Kimberly Crenshaw, to begin with, but also Patricia Williams talks about similar contexts. Then you have Patricia Hill Collins and Selma Bilge, who talk about intersectionality in very, very different ways. Yeah, and it is predicated on the experience of violence by African American women in the United States in the first instance. From there, of course, you can extrapolate, and it's also based. It's not an originary concept in that sense. It is based on the the African American experience historically. Even when Crenshaw writes it, she is mindful of that history. So you need to then say, okay, what are the ways in which this has been theorized? And will that manner of theorizing a concept work? Or can that term intersectionality be opened up differently for different contexts? And you have some very recent work by Mary Romero, for instance, where she's put together a collection of work from across regions and cultures that speak to the concept of intersectionality. So I think that it's little help to say intersectionality is all rubbish. I know several Dalit groups. I know several scholars belonging to minority groups, to marginalized groups, actually finding the idea of intersectionality very useful. Yeah. And even within governmental forums, if you're talking about Durban, or you're talking about the Office of the Special Rapporteur on Racism and Xenophobia, you are talking about, and now we have a Dalit woman who is Special Rapporteur, KP Ashwini. I think that we do need to try and relocate these concepts rather than dismiss them. And so I've worked with the idea of intersectionality, and I've worked without it as well. You can describe it. It's what the work you do is not limited to the use of the concept. But the point is, how do you articulate the concept contextually? And I think this whole idea of law and theory in context is something that is extremely important. So, kind of returning very in a roundabout fashion to your question on feminist legal theory in India and Europe, American traditions. I think in very fundamental ways, in the ways in which we imagine the idea of dignity, the ways in which we imagine what justice should mean, there is a commonality. I wouldn't say identicality, but there is a commonality. There is a possibility of solidarity. But the realities of the global north and the global south are very, very diverse and very, very different. And so in building what Suraj Yengde, for instance, calls sibling solidarity, in building sibling solidarity, we need to really think through what the constituents and referents of that solidarity should be. And I think in that, our approaches as belonging to different regions or different spatial geographies will be very material to that to that effort.
Right. I think that's a very important point, and it makes sense for anybody looking at feminist thought in most spheres. How does one engage with the contradictions within feminist legal activism? For instance, there's a debate between the demand for carceral punishments and also transformative justice. So, how do we sort of engage with these so-called contradictions?
Yeah, I think feminist movements and women's movements are as internally diverse as our societies are. And, there's also governance feminism. Prabha Koteshwaran has actually written about it. But for me personally, I think also this also has to do with my very long preoccupation and exposure to the question of carcerality and in the context of arbitrary state action. For me personally, I think it's a contradiction in terms. We can't, as feminists, ask for justice to be transformative and carceral at the same time. If it has to be transformative, you have to find a way out of carcerality. Confinement, imprisonment is not an answer, and much less arbitrary killing. Yeah. So, for instance, we had the encounters in Hyderabad in 2019 when Disha was raped and killed. 3 suspects were just rounded up and shot in the dead of night, even before the investigation had been completed. And the actions of the police were lauded importantly, I mean, not just by the family, but by women and women's groups who, in fact, celebrated the police officer in charge. And this just sets in motion another spiral of actions. So yes, you shot these 3 men and say you've sorted out the question of justice for Disha. But what about the murder of 3 people that has just happened? How do you intend to sort that out? So carcerality brings in its wake a spiraling crime cycle. And we have in courts constantly been saying that even if it was a shooting or a murder by the police or armed forces in self-defense is a defense that will come up during the trial at the evidentiary stage. No, you can't just shoot and then say, okay, the case is open and shut because they were responsible and they lifted their guns and we shot them. You can't shut a case when murder has happened. There has to be an FIR, there has to be a trial, and there has to be a finding through court that the police are not guilty of murder. And I think that this argument is extremely difficult particularly in the context of crimes like rape and murder of women. Because one, the immediate response is to shoot the accused or the convicted. Either way, you had one, they can die mysterious deaths and you execute them. So you had one set of actions by the state in the Nirbhaya case, and you had another set of actions by the state in the Hyderabad case. And we often recall the fact that we need to assuage the grief and sentiments of the family. And my position, it's also difficult to explain. I mean, when there has been a violent death, it's difficult to articulate this to the bereaved. But the point is that the object of justice, or the object of going through a judicial process and delivering justice, is not really to provide satisfaction to individual victims' families, because that satisfaction is a very slippery slide. And my question has always been, okay, so you've shot 3 men. Does that mean that there is no grief at the loss? That loss remains. The grief remains. So what is it that this vengeful killing of suspects or execution of suspects actually does? So in that sense, and here, I kind of bring the idea of carcerality together with the larger continuum of arbitrary state action. What does it do, and what is it meant to do? What is reparative justice actually meant to do? It is meant to find ways of working through the anger and hurt and grief and loss of the bereaved without spiraling the crimes by the state. And there's no point in saying, no, we can't do it. That is the difficult route of transformative justice. It's not easy. And it is a route it is a modality of state that falls unequally according to the graded social order. Yeah. So you saw what happened in Hathras, and you saw what happened with Disha. And you saw what happened with Nirbhaya. And you saw what happened in Khairlanji. Also what happened in Kilvenmani, which Maithili Shivaraman writes about so beautifully. Yeah. So I think that the difficult road that transformative justice and transformative constitutionalism must traverse is that road that opens out a channel of communication with people and communities that are bereaved, to speak about the ways in which crime must be subjected to due process. There must be convictions, but there must not be death penalties. And there certainly must not be encounter killings. Otherwise we can't. I mean, we also heard, we had reports, for instance, of Nirbhaya's mother. And I feel really very, very helpless at times when I, read the statements of parents of, girls who have been killed like this. But also the 3 boys who were shot in Hyderabad had parents, yeah, who were given no explanation. as to why their sons had been shot. But I do feel, I feel at a complete loss at both ends. What is the language that we have? I mean, in all this debating on what is fair justice, how can we bring culprits to book, and so on, what is the language we have developed, and how much of energy, intellectual and emotional energy, have we invested in developing, in developing a language of reparations or restitutions that avoids, brutal carcerality. So yeah, I mean, carceral justice for me is really a contradiction. It's a contradiction in terms.
Again, I think it's a very important point considering everything that is happening in terms of politics at both the national and international level. So, we can, of course, have more discussions on it. But I also want to ask you about how you have talked about the importance of interrogating impunity. And I want to ask you in relation to caste, in the sense that can we theorize caste-based impunity beyond the legalistic frameworks?
But I think caste-based impunity has, in fact, been theorized in the first instance beyond the legal framework. Like I said, I mean, I began with Article 17 of the Indian Constitution, right? And I think that the question of caste-based impunity is at the center of the entire body of anti-caste writing across centuries, in fact. The challenge to caste dominance and the resistance to the violence of caste through social movements have actually been challenges to caste-based impunity. And it is that wisdom and that experience that we find Dr. Ambedkar brings in to both the the description of the brief description of constitutional morality, and more importantly, the enunciation of Article 17. Yeah, because what Article 17 embodies is not a legalistic framework. What it embodies is the popular anti-caste challenge to caste impunity. And as long as we reduce constitutional enunciations to legalese, we will never be able to actually confront and challenge dominance, which is what is required in transformative constitutionalism. So I think we have the tools there. But the point is, how do you use those tools how do you broaden the use of those tools to actually bring about social transformation? Like I said, from the level of the community, family, community, and neighborhood to the national level. How do you grow that? And that is, kind of really the challenge to an understanding of caste. But the challenge to impunity, the problem also is that this reduction of not just the constitutional, but the constitutional framing of 15 and 17, also of 23, is reinforced by the framing in special legislations, like the Protection of Civil Rights Act, or the Untouchability Offences Act, or the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. These, in fact, reinforce the foundational framing in Article 17, the Bonded Labor Act. Yeah. But what happens strangely within constitutional courts is that these acts, although they are transformative in their enunciation, are reduced and truncated to legalese. And then, you want people to say, okay, he used this word to abuse you. How do you know that his intention was to abuse your caste? Okay, he raped you. How do you know that his intention was to rape you because you were Dalit? This kind of absurd interpretation in law and by courts happens because you have actually truncated a constitutional protection that is transformative and based on a history of anti-caste philosophy and resistance. Instead of locating your interpretation within that historical context, you reduce it, to ways in which you might look at tax law or, motor vehicles accident, so you want the ingredients. Yeah. The term that is used in law, what are the ingredients of the offense? And are these ingredients of do these ingredients of the offense speak to the motive? Do they speak to the intention? Can you prove it? What is the connection between intention and action? This happens when you read through a legal reductionism. And that is really something that we are challenging. In fact, when I wrote Tools of Justice, and I didn't actually plan to write it in the way in which I did, but when I wrote it, I was working on different sets of concerns in my own research, in the cases that I was working on. I was working with Dalit groups. I was working with Adivasi groups on land, with Dalit groups on the question of untouchability, with women on the question of discrimination, sexual harassment, hostile environments, with persons with disabilities on the ways in which the lack of barrier-free access is in fact a denial of the right to liberty. Yeah. So I was working on different pieces, and somehow to me, all of them seemed very connected. So hostile environments for me, although I got the language from Vishakha versus State of Rajasthan, but more than Vishakha versus State of Rajasthan, from Bhavri Devi and her struggle, the idea of hostile environments was something that I found one could, in fact, deploy in very different ways in each of these contexts. The question of minorities, particularly post Ayodhya in 1992 and then post Babri Masjid. Post Babri Masjid and then post Gujarat. So it was that threading together that kind of led me to open out one field after another and to try to look for the connections between them. So, and that is the point at which I found that, the jurisprudence on non-discrimination is one that is characterized by dissociation and by disconnect. So you are one, dissociation because you are setting yourself apart from what you are looking at, and you are not willing to see the connections between one part of the problem that's in front of you and another part of the same problem. Yeah. And disconnect because you are looking at it in a way in which you would look at ordinary crime. You are not looking at it in a way in which its context comes alive and gives you the wisdom to judge. Yeah. So those really were my uh, kind of what should I say, my guides when I was trying to open out various fields of discrimination, non-discrimination, and discrimination.
Right. So, do you think that there is also a gap which is increasingly widening between constitutional promises and legal realities, particularly for communities of marginalized origins?
Yes, there is certainly, but that and that has to do uh, with several uh, with several uh, problems that we have that occur simultaneously. One is a question of representation. Yeah. The point is not that more women will give justice, having more women in the judiciary will give justice to women, or having more Dalits in the judiciary will give justice to Dalits. That it's not a mechanical application. The point about representation is that the more diverse your criminal justice and civil justice and constitutional courts are, the more diverse your courts of original jurisdiction and your courts of appellate jurisdiction are, the more the working contexts of judges and officers of the court will change. And the moment your working context becomes more diverse, the moment you are in daily professional conversations with people of different locations, of different backgrounds, your own sensibilities are forced out of their cocoons. And that is really what representation does. So there are two parts to the need for representation. One, it is a plain justice, representation as justice requirement. If you have, there has to be a proportional representation. You see it, for instance, in the Women's Reservation Bill debates as well. You need proportionate representation. And that is a basic justice requirement. You can't say, no, there are no people, or we can't find people, or, for instance, the unwritten rule in the Supreme Court at some point that you should have only one woman justice at a time. And so some judge was waiting for the one woman justice in the Supreme Court to retire before she was appointed. And this was in the first lot of women judges who were appointed. So it's not a question of tokenism. That is tokenism. Representation is different. So why don't you have a situation where if you have 40 judges in the Supreme Court, 20 are not women? And among the 20 men, all social categories are equally represented. So are all women, so among women. So it's not just a question of you bring the top 40 women in and the top 40 men and they will constitute the court. No. The question of representation is, in a graded society, is that representation has to speak to that graded society. So that's a basic tenet. And then the second part of it is the minute you accomplish that, and our best judges resort to equivocation on the question of representation. The minute you accomplish that, then the working context of judges will change. And the minute their working contexts change, and the minute the working contexts of the officers of court change, there will be a forced change in the ways they think, what Dr. Ambedkar called notional change. And I think that would certainly lead to a gradual lessening of the disconnect between what is delivered through the law and what is required in society in terms of justice.
Sorry, I was muted, didn't realize it. Right. Okay, so I also have a few pedagogical, institutional kind of questions. One is that would you like to see any changes in how law and sociology are taught in Indian educational institutions?
I think, I mean, I actually would be speaking from a by now ancient experience. I was in a law school I mean, I left the law school where I was teaching 15 years ago. So that's a long time. And of course, at the time that I was talking, I mean, I was teaching, you know, there was no social consciousness in law courses. And so perforce, and because I was trained both in law and in sociology, I would actually I remember teach family law and criminal law in my sociology class. And I would teach it differently, as I thought it ought to be taught, with a lot of texts by feminists, by philosophers, by creative writers. And creative writing is a huge archive that we haven't begun to tap enough, I feel. Um, so, I mean, there were those moves that I made. But I think that the situation is very, very different now for uh, quite a few institutions, although those institutions would still be a minority if you looked at in numerical terms across the country, those would still be a minority. But I think that there is an increasing conversation between social science scholars and legal scholars. But I do think that the question of gender really needs to be revisited and opened up in radically new ways. It can't, you can't have you shouldn't need to have a separation between gender studies and queer studies, for instance. Yeah, it should be possible for a disciplinary space to meld different strands of gender studies in such a way that you don't actually have a dominant and an additive strand. Yeah. So how do you accomplish integration is a bad word, but how do you accomplish that interweaving, within a disciplinary space? The second is, the question of the environment. And, I've of late also been reading a lot on the human, non-human continuum, and the ways in which we tend to imagine rights and environment and societies as limited to human societies, whereas the human is always in close conversation with the other than human. Yeah, whether this is ecology or environment or animal rights or habitats or whatever. There are there is a very real uh, uh, you know there is a very real and live relationship between the human and the non-human and the other than human, that in fact keeps the human in place. Yeah. And I think that we haven't really paid attention to broadening the discourse on rights while keeping all of its complexity to a meaningful and live engagement with new and upcoming work on the environment and ecology. You have now, for instance, in the age of the Anthropocene, you have the entire debate on the Manthropocene, which only comes into being, in a sense, through weaponization and violence. and is fundamentally gendered. But you do need much better engagement with ecologies, with diverse ecologies, which each of which uh, you know uh, spawns its own uh, you know ecologies of suffering, of harm, uh, of uh, threats to life and existence, also to liberty. So I think that that there is a need to bring all of those different strands together. I think Adivasi movements, for instance, are have accomplished that connection between the environment, ecology, and human existence the best so far. But I also think that we need to find ways in which that conversation, like the conversation on gender, becomes part of the understanding of the social, not limited to human sociality.
So, are there any questions that have remained underexplored in feminist legal research?
I don't know. I mean, I don't even think we have sorted out the age-old questions that we began with, no? I'm sure there are, and I know that there are a lot of scholars who are coming up with a lot of very interesting work uh, in representation and communication and media and in a whole lot. I mean, I could just do a kind of a laundry list of areas that I actually find quite interesting and captivating. But my own problem is that I have been obsessed with the problems that we haven't really got around yet. Yeah. And the manuscript I'm currently working on, for instance, is a book that revisits the Ramizabi case of 1978, and tries to look at the period from, and even if I just took Hyderabad, to look at the period from 1978 Hyderabad city to 2019 Hyderabad city, when Disha was killed, yeah, and beyond. And it's like as we speak, there's more and more that is added on. Um, we've been speaking about Kashmir. We've been speaking about the Northeast, and we've been speaking about AFSPA for ever so long. Yeah. But can we stop speaking about any of that now? I mean, we have Manipur before us. We have Kashmir before us. Have we sorted any of the problems? 2019 was Disha, but then we've seen the Calcutta incidents more recently. So it's like, in a sense, every time I try to step out and say, okay, is there something else? There is this very tangible force that pulls me back, saying, but what you started way back then, you're nowhere near reaching any kind of resolution that even gives you a way forward, because the way forward is not commission reports. The way forward is transformative constitutionalism. How do you actually impact the ways and the regularity with which this kind of violence recurs, and the regularity with which the state unfailingly abdicates? Yeah. So, yeah, I mean, there are issues. I wouldn't say there aren't, but I think somewhere I'm kind of stuck. one could say, in a time warp, but it's not actually a time warp, because every time I think it's a time warp, there's something that's happening right next door or in front of me. Yeah.
Last question. This is a question also coming from what we do at Doing Sociology, because it's a bottom top approach in the sense that we provide a writing space to young people while having conversations with more established scholars. So, how do you think emerging scholars should approach this challenge of writing, particularly about power from within powerful institutions?
I think they should just write. I mean, like, I think it was Sabine Mahmood who said, fear is a line in my head. You should just write. It's risky. I'm not saying it's safe. In today's environment, particularly, it's risky. But there's no other way. And the other thing that I have learned is that the more you write, the easier it becomes, both in the act of writing and in the imagination of what you might write about. At both levels, it is only if you write that you know, and that dilemma is really never quite sorted out. To this day, when I start a piece of writing, there are sometimes a week, 10 days with my Ramiza B book, I think 1.5 months, when every day I would open my computer and read something and do some translation and read again, and not be able to put down a single line on paper. So there will be those blocks, but the blocks are not really blocks. Those blocks are times during which you are processing how you approach what you're looking at and what you want to write. So I somehow don't really like the term writer's block, or whatever the block in writing. It's not a block. You do need to take a bit of quiet mind space where the hand is not working, in order to be able to sort that thought out. And it is time consuming. So there are no shortcuts. There is no easy way out. AI is not the answer. Chat GPT is not the answer. And now, of course, you'll get found out even more easily if you do chat GPT. Language barriers are not insurmountable. I have worked throughout, when I was in Nalsar and when I was in CSB, all 20 years, 10 years there, 10 years here. I have worked with students and scholars with serious English language difficulties. My class or my meetings were always spaces where people could express themselves in any language. In fact, in the language that they were most comfortable with. And we would always find that there was somebody who would be able to translate. I myself speak 3 languages, so it was not a problem. But there were also always people who could translate what I didn't understand. But I think that important point is to bring back the vernacular into academic writing. It's there in academic discourse to a large extent. But, in our university system, except in some state universities, in our university system, writing in vernaculars is not something that is deemed to have value. And yet, it is only through expressing yourself in a language that you're most comfortable with that you can actually get the first cut of what you want to write out. So if you do want to write in English, that's not a bad aspiration, but it's not a necessary aspiration. But if you do want to write in English, there are always people you can work with friendly translators who you can sit with and co-translate into English, which is also something that I have done a lot. That I used to just sit with people who wrote in other languages and help them to translate it into English. And then smoothen the English with their consent at every stage. So there are ways in which you work around language difficulties, but the basic minimum is that you must write and don't bother about the power in the institutions. It's not only in the institutions. You step out of the institution and it is completely dense with power. So you don't stop breathing and walking or living. I think the same thing to do with institutions. One just has to keep up the momentum. One has to write. One has to be able to say the emperor has no clothes. And that's basically what I've also it's been something that I've also discussed constantly with research scholars and students who work with me.
Thank you. Thank you for stating that out loud in so many words. And this has been a very illuminating conversation. So, thank you once again for giving us time. And I hope that our viewers and our particularly young scholars find it useful. So, thank you, Professor Kannabiran, once again.
Thank you. Thank you, Ritu. Thanks.